What should do I need to copy your JA in?
No, because he will. Well, you can do if you want, but
we're streaming now, just to let you know.
Oh, right.
I've not been told. He hasn't said anything. I don't even know her. I don't know if she is. And I've been trying for weeks now. You keep saying about handover. Well, there isn't one. Oh, absolutely. I'm really quite annoyed. To the challenges.
I'm happy to get a fair crack of the afternoon.
Okay.
It won't be long until.
So Rebecca.
Sorry?
It won't be long until May to finish.
Yeah, we made it. See how we get on. I mean, as you know, it depends how much.
I think it's quite
spent.
Years ago, I'm like. This is really nice. Let me leave.
So you've been in the court since COVID.
You will.
I'm so sorry.
Have you been in the
First
court?
time.
Okay, so when you sit there, and when you can move to there. That's just to give, because your learned friend will be closer that way. So that's all you need to know, and then you can take your mask off to speak.
Great. I can sit in this one?
No, so we'll be there.
Right. I'll move. Thank you.
Right.
Am I? You want me slightly further over there? That's right.
No, it should be okay, because your learned friend's going to be sitting right.
You did?
Okay.
So that should be fine.
Ah.
And as I said, you take the mask off and speak. Just when you sit, you just sit there.
Yeah, I'll sit there and I'll move this.
All right.
Great.
So are you ready? Ready to go?
You need a week.
I was just curious.
Amazing how quickly you forget.
Don't worry, I'm here to remind you, that's for sure. And are you ready to
We
go?
are good, yes. Thank you very much.
So just a reminder, glasses. What's ready? Court rise. Appeal in the matter of Awards Drinks Limited in liquidation and the Commissioners for Her Majesty's Revenue and Customs.
May it please the Court, I appear with my learned junior, Mr. Bedenham, on behalf of the appellant in this matter. My learned friend, Mr. McGurk, appears for the respondents, the commissioners.
Yeah.
May I start by saying what a pleasure it is to be back in this building after a year and a month. It's not quite the same when it's done virtually.
Good. Excellent.
In terms of housekeeping, I hope your lordships and your ladyship have two bundles. One is a core bundle, and the second is a supplemental bundle.
Yes.
I have asked the court associate, and he kindly agreed to hand up a very short chronology, which was simply prepared by me as I was working my way through the papers. It's not going to unlock the case, but it's there if you would like it.
Right.
There is an application by my learned friend to rely on some further material, which we oppose. What we've proposed to do is let the learned friend address you on that should the need arise in the course of his submissions, and I'll come back if I need to.
Okay.
My submissions will be grouped into three main parts. Firstly, with your lordships and your ladyship's permission, I will go through briefly an overview of the legislative framework which governs intra-EU transactions in excise goods. That involves having a quick look at the Principal VAT Directive, and the Excise Directive, but I shan't belabour the points because this court is thoroughly familiar with those areas.
Yes, I think so.
Secondly, I will spend more time, if I may, devoted to precisely how the Commissioners articulated their case in writing and to a limited extent orally before the tribunals below. My third section will then turn to look at the consequences of the Commissioner's case in the light of the legislation that has been seen. And I'll then briefly address your Lordship.
When you say the Commissioner's case, wasn't it really your case?
Well, my Lord, the point of the attempts we made to flesh out exactly what the Commissioners were saying was to elucidate exactly what their position was.
Their position was that these were correct assessments, and it was for you to say they were wrong.
But absolutely, the burden was on us to challenge two VAT assessments.
You had to establish that the sums involved were not the proceeds of sales effected by you in the United Kingdom. Is that right?
We had to establish that we were not the taxable person who had made identified supplies in the United Kingdom.
Yes.
But in order to do that, we sought to establish precisely what.
But I mean, HMRC didn't have to present a case to the FTT, did they? I mean, they said these are assessments we've made. We believe them to be correct. It's for you to say they're wrong.
Well, if they had simply responded to all of our requests for clarification as to exactly what their case is, and then metaphorically sat down, I doubt we'd be here. But what they chose to do, quite rightly, was to seek to narrow the issues between the parties. Right. And it is crucially important, we say, to understand the basis upon which the VAT assessments were raised.
And the issue before the FTT, I mean, in front of the FTT, your client accepted that the sums in the bank account were the result or proceeds of sales made by it. The only question really for the FTT was whether those sales were made in France.
The question for the FTT was whether or not those proceeds of sale were attributable to taxable supplies in the United Kingdom.
Yes, but there was no issue as to whether they were the proceeds of sales made by award. That was accepted by award. Award said, we made these sales. These are the proceeds of sales, but we made them in France.
Well, might I put it the other way round, which is it was a necessary part of the Commissioner's case that we had.
No, it was your case. Your case was. Sorry to interrupt you, but I think this is a slight difficulty about this. We know what their case was. We've assessed you. Prove they're wrong. So you go to court. You could have said to the FTT, we never sold these goods at all. Nothing to do with us. But you didn't. You said, yes, we did sell these goods, and the money in the bank accounts came from those sales, but they were in France. And you failed to show they were in France. I mean, I find it difficult to see what's left.
Well, my Lord, what was crucially left was the basis of the transactions which underlay the assessments.
But that didn't need to be proved.
Well, my Lord, it did, because the assessments themselves were based simply on the receipt of money.
So,
and I understand it to be common ground that receipt of money by itself is not a
but
VAT.
they said that that was receipt of money from sales that award had made. You accepted they were proceeds from sales that award had made.
Well, my Lord,
it was just a question of the location of the sales.
Well, yes, with respect,
Yes.
I entirely agree.
But are you now saying they were not the proceeds of sales made by award?
No.
You accept they were proceeds of sales by award?
We accept we made sales of goods.
And that the money in the bank account were the proceeds?
Yes, that's right. But the crucial
So
question...
you sold the goods, the money in the bank account are the proceeds. What's the issue?
Well, my Lord, the assessments were raised on the basis simply that sums had been received by a UK registered tax.
Yes, but which you accept for the proceeds of sales.
Which we do accept with the
By
proceeds
you.
of sales.
By you.
The place of supply rules determines whether or not the UK had fiscal jurisdiction to tax those
Yes, I
supplies.
appreciate that. The revenue said, yes, they were in the UK. I mean, that's the basis on which they make the assessment. You said, no, they were not in the UK, they were in France.
Well,
And you failed.
Well, that was our case in the sense that we said we have made these sales.
We've made these sales, we've made them in France.
But in the course of making that submission, we had elucidated from the commissioners a number of salient facts.
But I don't see how any of that affects the basic structure I'm putting to you.
Well, My Lord, because if two parties to litigation have agreed what the facts behind the relevant
Well,
dispute are-
the agreed facts were, in the sense there was no issue on this, that the 32 million odd deposited in cash in the various bank accounts were the proceeds of sales made by your client.
we are saying that income was attributable to the sale of excise goods. Yes.
By you.
That was our business.
By you.
By us.
But you're now, and the only issue for the FTT was whether those sales were in France or not.
My Lord, no. The issue for the FTT was whether or not we had displaced the burden, beaten the burden, of showing
which you
that the
sought
goods-
to do by saying that we made the sales in France.
That's correct.
And you failed.
The endeavour was to show that the commissioners had not established on the balance of probabilities that the supplies took place in the United Kingdom.
And your positive case was we sold them, but we sold them in France.
That was a positive case. That was not accepted. That doesn't follow from the rejection of that case that the criteria for a sale in the United Kingdom are met.
But it's for you to establish the assessment is wrong, and I don't see what else is left.
My Lord, we established the assessment is wrong by virtue of an analysis of what the relevant facts were, which the commissioners accepted.
The facts were put before the FTT. I mean, have I not got it right that those were the essential facts?
No, because the essential...
Which of the facts I've put to you are wrong?
Well, the facts that you've put to me, my Lord, are not sufficient to establish a taxable supply in the United Kingdom.
Surely they're enough to raise at least entitle the fact-finding tribunal to conclude that the assessment was sufficient. I mean, if we have enormous sums being paid into bank accounts up and down the country, and you are a trading enterprise, whether wholesale or not, dealing in sale of alcoholic liquor, I mean, doesn't that itself give rise to an overwhelming inference that these are part of your taxable turnover?
Well, my Lord, my client was a UK registered taxpayer, but its entire business was conducted under bond in France.
Well,
and
that begs the
other
question.
countries.
I mean, we have these transactions, which it was for your clients to explain, and they produced an explanation which was rejected as a cock and bull story.
And the consequence, however, of the interlocutory skirmishes that took place were that we sought to narrow the issues between the parties by seeking to understand exactly what the Commissioner's case was. This case turns on the extent to which it's open to a party to seek to cooperate with the other side to delimit and narrow the issues for the purposes of the tribunal.
What I find absolutely really difficult to understand is how, you accepted you sold these goods, and that the proceeds of sale were paid into your bank account.
Yes.
So I don't understand. I mean, I really don't understand in those circumstances how, having failed to establish that the sales were in France, what is left of your positive case that these assessments were wrong?
Well, it was accepted by the commissioners that these particular goods were originated in France. They were French goods, and they must at some point have been under bond in France. It's the entire purpose behind the commissioner's case is to say these goods were in France, they then came to the United Kingdom, and they were subject to a sale. Otherwise, you don't get the territorial...
Well, you accept they were subject to a sale.
Well, my Lord, I accept that there was a sale of the goods and also the possession and control.
And you accept that the money, and you accept that you sold them.
Well, we accept that we sold them. We put forward a...
Well, that was your case. We sold them.
It was. That was our positive case.
And you accept that the money in the bank, your bank account, were the proceeds of those sales.
My Lord, that's correct. But what that doesn't cater for is the fact that the actual act of removing these goods from France. So let's just start with common ground. It was common ground that these goods had been in France. Why? Because it was every part and parcel of the Commissioner's case that it was the arbitrage opportunity between the excise rates in France and the excise rates in the United Kingdom that led to the inward diversion. And it was their case throughout that these goods were in France, they were smuggled into the United Kingdom, they were then sold. That sale took advantage of paying excise duty at a lower rate in France and taking advantage of the fact they could then undercut the competition in the United Kingdom. That's the inherent nature of an inward diversion fraud. And that arbitrage opportunity justifies the transmission of the goods from France to the United Kingdom. So we start from the premise that it's inherently bound up in the Commissioner's case that these goods were indeed in France. The question then becomes, who is it that is said has dispatched or delivered these goods from France to the United Kingdom.
Why does that matter?
Because the person who is liable for VAT on an intra-community cross-border supply turns on who is the person who has dispatched the goods and who is the person who has received the goods, and in what capacity did those entities...
But if you sold the goods in the UK, were you not liable to account for the VAT on those sales?
If we had sold goods in the United Kingdom that were held in the United Kingdom to a customer, then yes, of course. But once the premise is we have sold goods not in the United Kingdom, because these goods are in fact in France, and once we have, once it is accepted by the commissioners that we weren't in control of the goods when they were being transported across a border, precisely because when I show you the further and better particulars the commissioners put forward for the tribunal, they accepted that it wasn't us who had delivered the goods across the border. They accepted that the persons who had delivered the goods across the border were a different supplier, possibly a customer of ours. They were responsible for the movement of the goods cross-border. That wasn't us, and they weren't acting as our agent.
Well, I'm not sure that's a fair interpretation of what the commissioners actually said. I'm obviously we'll be coming on to this. But it seems to me, I mean, the point they were making was a much more limited one. They were not putting forward a positive case to that effect. That is not the same as asserting the contrary.
Well, my lord, I hope to persuade you in due course when one looks at the further and better particulars in context, that it's quite clear. They were saying, we don't say you were the supplier.
Well, you didn't have to. It was for you to establish the true relationships.
But it was accepted that the goods had in fact moved cross-border. That was a necessary part and parcel of their case.
If you sold the goods in the United Kingdom and received £32 million odd by way of price for that, were you liable for VAT on those sales?
Well, my lord, if we sold those goods cross-border from France to the United Kingdom, no, we wouldn't be, because if we sold them to we'd only be liable for those sales if we had sold them to a customer at a retail stage who was not a business person. If it was a business-to-business supply cross-border, the liability would in fact fall upon the recipient, the business recipient of those goods in the United Kingdom, to pay what's called acquisition VAT, and they would then have a charge to the output tax, which they, if they then made a subsequent supply of the same goods, would be able to recover as input tax.
So if you had sold them from the bonded warehouse or houses in France to a business customer in England, you would not have been liable for VAT on that sale.
They wouldn't have, if they had been removed from the warehouse, physically delivered other than in duty suspense to the United Kingdom to a business customer, the proper analysis would be that a charge to acquisition tax arose in the hands of the business customer, and we would have made an exempt supply under the French VAT legal regime, an exempt supply with refund.
And so you wouldn't be liable?
We wouldn't be liable.
But that wasn't your case before the FTT.
Well, as my lord,
I mean, it was a very interesting hypothesis, but it's not actually what you put forward.
Of course, my lord, and I suffer from the
Well, you can't.
problem in this case.
Well,
that,
it's not.
the
It's
version
not.
of events we put forward wasn't believed.
Well, that's it, isn't it? That's the trouble.
But it doesn't follow. It doesn't follow from the rejection of my client's account that the assessment was right.
But it doesn't follow you can assert a different story.
Well, it's not a different story, my lord. It's a story
It is,
based on
isn't it?
the
Forgive
common...
me, but it's a totally different story. You're now saying that you sold business to business, France to the UK, whereas before you were saying you sold to cash and carry wholesalers, no, retailers, which was then altered by Mr. Judd in his oral evidence to wholesalers.
Well, my lord, if I may say so, that's a little unfair because you were putting to me a hypothetical.
No, but I thought you were putting to me a hypothetical. I thought that's what you were suggesting might have happened and would account for the cash in the bank accounts.
My lord, once we no longer had physical possession of the goods, my client's not in a position to say what happened.
But he sold them.
Well, on his view, he sold them.
He sold them.
That account
And he
has not been
received the
accepted.
cash.
What has been accepted, however, is that it wasn't us that moved the goods. So something must have happened somewhere.
No, it hasn't been accepted with respect. I mean, it's just HMRC have not put forward a positive case that it was you or your agents who moved the goods, but it's perfectly possible that is in fact what happened. We just don't know, because your clients failed to put a credible story before the tribunal of fact.
Well, my lord, my respectful submission is that the further and better particulars do indeed say.
Well, you better show us
Yeah,
those,
I mean,
Mr.
that's
Beale.
ultimately a question of
I think
construction. I
okay,
suppose.
you can see where we have some problems with this appeal, but we'll let you develop your submissions now.
My Lord, it's fair to say that they're not problems I hadn't anticipated.
I'm
to a
sure.
certain extent.
I'm sure.
But my answer to them remains that it does not follow that because our version of events was not accepted, that the place of supply by a taxable person is the United Kingdom, and that the person who is the supplier is my client.
Thank you.
So, if I may, I'll start with the relevant legal regime. Would your lordships and your ladyship please turn up Bundle of Authorities, tab 1, which is the Principal VAT Directive. If we could start, please, at Article 2. Now, VAT, as I'm sure this court is aware, is a transaction-based tax. It charges VAT on the supply of goods or services. We can see that in Article 2(1)(a). What that says is the supply of goods for consideration within the territory of a member state by a taxable person acting as such shall be subject to VAT. There's then a separate chargeable event under 2(1)(b), which is the intercommunity acquisition of goods for consideration within the territory of a member state by a taxable person acting as such. So that's the B2B supply, business-to-business supply in 1B, Roman 1. Now, a small wrinkle in this case, because it is common ground that the goods in question are excise goods, is the fact that one has to take into account then sub-Roman 3. And that says, in the case of products subject to excise duty, where the excise duty on the intercommunity acquisition is chargeable. So one ties in the point at which VAT becomes chargeable with the point at which the excise goods themselves become chargeable, subject to an excise directive 9212 that's now been replaced by excise directive 2008-118. I'll come to that in a moment. And that has to be within the territory of a member state by a taxable person. And one can forget everything that comes after that because that relates to facts that aren't relevant for here. One then sees in Article 14, sorry, I should say for the avoidance of doubt, if one looks at the bottom of page 4, Article 2, subparagraph 3 confirms that products subject to excise duty include alcoholic beverages. It probably didn't need saying, but it's there. Article 14 then deals
Sorry, you referred to a page number.
Yes,
I mean,
you did.
I don't have page numbers.
No.
And
At least I think our page numbers may be different. They're 16 and 17, I think.
I fear what's happened here is that Alona Junior's clerks had submitted a bundle which didn't have pagination. I thought that had been cured yesterday.
No, don't worry.
Sorry, I thought it was just the same bundle again. It looked completely identical. Nobody said what the difference
The only
was.
difference is there were 1 or 2 pages missing.
Oh, right. Oh, dear. Well, I've got the unpaginated
feel like
one as
before I
well.
go
But never mind.
It matters not. When I come to a missing bit, I may have to refer to the updated version.
Right.
Right.
Anyway, so internal, top of the page 17, Article 2.3 by the paragraph M7, which is
Ah, yes.
supplement. Alcohol is an excise product. I think that's uncontroversial.
Yeah.
Page 22, next page, Article 14. Supply of goods shall mean the transfer of the right to dispose of tangible property as owner. And in addition, one sees under Article 14, subparagraph 2, little b, that encapsulates not only the transfer of the right to dispose, but also the actual handing over of goods pursuant to a contract which is either a contract for the hire of goods or for the sale of goods on deferred terms, which provides that in the normal course of events, ownership is to pass at the latest upon payment of the final instalment. And that's 2 different ways of defining the supply of goods. The next page, which I hope is page 27, then deals with the place of supply rules. So ordinarily, under Article 31, where there's no cross-border issue, where goods are not dispatched or transported, the place of supply shall be deemed to be the place where the goods are located at the time when the supply takes place. So, plain vanilla case, UK, sale of goods, wholesale to retail, very straightforward. Supply of goods takes place when the goods are delivered, and VAT is chargeable. Article 32 then deals with a situation where goods are dispatched or transported by the supplier, or by the customer or a third person, In that case, the place of supply shall be deemed to be the place where the goods are located at the time when dispatch or transport of the goods to the customer begins. So in the ordinary course of events, if I hold goods in France and I dispatch them cross-border to the UK to a business customer, then the supply begins, and therefore the place of supply is the point at which the transport of the goods begins. Now, it's by way of derogation from that. Article 33 then deals with a position, and I think this is where one of your pages may unfortunately be missing. Article 33 in itself says, by way of derogation, the place of supply of goods dispatched or transported, etc., shall be the place where the goods are located at the end of the dispatch, where the following conditions are met. And those conditions, I think you probably do not have, look in subparagraph A on the next page. That's
We don't, I'm afraid.
We don't, yes.
one of the rather important missing documents.
Yeah.
Um,
Do you have it?
It led to me questioning whether or not the paginated version had been supplied, and it hadn't.
Sorry, we're all missing it, I'm afraid.
Yes.
I mean, if it's going to be important, you know, I could rush to my room and bring it down.
I don't think so, my lord. It's only this one particular.
It's only this one.
I've identified as being important. Could I just read it out, and then
Yes.
you can
Yes.
read it in due course? Subparagraph A covers the supply of goods is carried out for a taxable person or a non-taxable person, or for any other non-taxable person. And a taxable person is qualified. So forget taxable person at the moment because the qualification isn't relevant here. It involves things like international supplies and diplomatic and consular supplies. The crucial thing is that where the supply cross-border is to a non-taxable person, that's what's called a B2C supply, and that is the place of supply for that would be treated as the UK. And so if you have a French company that supplies a consumer directly in the UK, the place of supply is the UK for that transaction, and the French supplier, if it supplies enough in the UK, will have to be registered here for VAT. But we're dealing here, we say, with business-to-business supplies, and therefore it's the first rule in Article 32 that applies, and so the supply is where the dispatch of the goods starts. But why does that matter? Well, if the goods have moved cross-border, what that says is that there is a point at which the dispatch of the goods therefore started in France. And where those goods are being supplied to a business, the place of supply is therefore France and not the United Kingdom.
Yeah, I see.
Now, the quid pro quo of that place of supply rule is that when a business receives goods in the United Kingdom on a cross-border supply from France, there is an inter-community acquisition of the goods. And one sees that at internal page 30, next page, which deals with the place of supply of an inter-community acquisition of goods. The place of an inter-community acquisition of the goods shall be deemed to be the place where the dispatch or transport of the goods to the person acquiring them ends. So you have a supply in France where the dispatch begins, and you have an acquisition in the UK where it ends.
Sorry, that's Article 40, is that right?
That's Article 40 is the place of supply, place of acquisition, sorry, an intra-EU supply. And I'll come on to show you a case where the Court of Justice says in terms, this is all part and parcel of a means by which the tax is transferred from one fiscal jurisdiction to another. So you have a supply that ostensibly is starting in France, it's ending in the UK. Because consumption therefore will take place in the UK, the tax follows that transaction, and the tax gets put on to the supply in the United Kingdom where it will be consumed. Page 39, Article 68, says that in relation to inter-community acquisition of goods, the chargeable event shall occur when the acquisition of the goods is made. So when the goods are physically delivered to the person in the UK who has received them, that crystallises the inter-community acquisition of goods, and we'll see it gives rise to we've seen it gives rise to a charged tax under Article 2. That is a new chargeable event. It was only a chargeable event with effect from 1991, when the common frontiers between the member states of the EU came down. That allowed for non-monitored movement of goods between the various different member states, and so this charged tax was introduced. We then see on the next page, page 43, In respect of the intra-community acquisition of goods, the taxable amount shall be established on the basis of the same factors as are used to determine the taxable amount for the supply of the same goods within the territory of the member state concerned. So what is the value of the acquisition? That is determined on the standard basis that you would look at the amount that had been paid to acquire the goods in the United Kingdom. Ordinarily, of course, that would be the purchase price of the goods. Now, in terms of the different tax treatment of those two transactions, you've got a supply in France and an acquisition in the United Kingdom. One sees at page 57, Article 138 states that the supply in France will be subject to an exemption from VAT.
Sorry, that's which one?
Article 1381,
Right.
halfway, second to the punch on page 57.
Yep. Have it.
What that states is, member states shall exempt the supply of goods dispatched or transported to a destination outside their respective territory, within the community, by or on behalf of the vendor or a person acquiring the goods for another taxable person. Forget the rest. And then one sees under Article 1382b, the supply of products subject to excise duty, dispatched or transported to a destination outside their respective territory but within the EU to the customer for taxable persons subject to excise duty and not subject to VAT. Where
So
those
let's
products...
just taking this a bit more slowly.
Sorry.
Under 1381, member states shall exempt the supply of goods dispatched or transported to a destination outside their respective territory but within the community, so from France to England, by or on behalf of the vendor
or the person acquiring the goods. Doesn't matter, in a sense, who does it. The goods have to be dispatched.
by, dispatched, yes, I see, dispatched or transported.
So it's the physical movement of goods across the border.
I see, by or on behalf of the vendor or the person acquiring the goods.
But in addition, we then have a separate exemption for goods which are subject to excise duty.
Just around 4, yeah.
Except 2b is quite dense, and it has a number of subordinate clauses which don't make it easy to construe. But the thrust of it is that basically you have an exempt supply of goods, which are excise goods, in circumstances where those goods are subject to duty suspension arrangements. Now, why do I say that? Well, it's dealing first with the supply of products subject to excise duty, which similarly to 138...
So you're looking at 1382b.
So we're dealing here with products subject to excise duty. That's the first point.
Yes.
The second point is they still have to be dispatched or transported to a destination outside their respective territory, but within the EU, to the customer, for taxable persons, whose inter-community acquisitions of goods other than etc. are not subject to VAT, subject to Article 3.1. Well, that's the...
So wait, I'm just right. The supply of products subject to excise duty,
Yeah.
dispatched to a destination outside their respective territory but within the community. So it's the supply to the customer,
Yes.
by or on behalf of the vendor or the customer for taxable persons.
Yes.
What does that mean, for taxable
what's the
persons?
syntax there? Yes,
Well,
right.
the way I pass this particular paragraph, and I've never found it easy, is simply after taxable persons to stop, because in fact the qualification under Article 3.1 is thoroughly confusing, but it seems to qualify non-taxable legal persons. It's possible, I suppose, that it covers 3.1, and what's intended here is that as opposed to the B to C supply rule, if in fact you're using duty suspense arrangements for a customer, which would be a B to C supply, for so long as they are duty suspended, they also benefit from the exemption. I think that's the proper way of reading it.
Where do we get the duty suspension bit? I mean, where does that...
Well, that unfortunately is the key bit, and it's right at the end of this rather long sentence. It says where those products have been dispatched or transported in accordance with Articles 7, 4 and 5 or 16 of Directive 92/12. That, unfortunately, is no longer the directive that applies, but those particular provisions now find echo in the excise directive, which we have behind tab 2, which deals with duty suspended movements. So what's the thrust of this? So it has to be a supply dispatched to the customer. So that's the key difference my Lord alighted upon. So it's the customer, but the customer is for taxable persons or non-taxable legal persons whose intercommunity supplies of goods or other acquisitions are not subject to VAT pursuant to Article 3.1, where those products have been dispatched or transported in accordance with Article 7.4. So I think what that's aimed at is extending the scope of the exemption to certain supplies when they are duty suspended supplies made to a customer. What I consider is not entirely apparent is whether that customer can be a natural person or still has to be either a taxable person or a non-taxable legal person.
These provisions are never easy. They're all the more difficult when you don't have a factual basis to apply them to. I'm totally in the dark as to really why we're looking at these just at the moment. To what set of facts are we going to be invited to apply these provisions? Then in a sense, it's easier to follow them.
Yes. But the set of facts...
Where do we find the facts to which they're to be applied?
The set of facts will be shown in the further and better particulars, where it's accepted that there was...
These are the facts, although they didn't feature before the FTT, apparently.
Well, they didn't, because the FTT didn't take them into account. And that's
Oh, were they advanced to the
Yes.
FTT? Right, okay. Rather inconsistently, though, with the case that was put to the FTT.
Well, my lord, I can show you how it reflects the Upper Tribunal. And
Are these alternative cases that were put?
That they were put on the basis that, in the light of the way that the Commissioner's case was pleaded out, even on their case at its highest, the facts did not establish.
I mean, I'm inclined, I have to say, and I slightly rebel against the idea that you're going to take us to CJEU decisions. I mean, I'm slightly inclined to think we might make more sense of all this if we knew what the factual basis was to which we're going to be invited to apply the provisions, incidentally, for the first time.
Let me flip my submissions around then and set out the nature and extent of the Commissioner's case. So that
All right, so let's sort of go to that.
and I'll come back to this.
Yeah.
I mean, I fully accept 2B is not the easiest.
Yes.
It's not. I mean, it is quite complicated.
I mean, it's fair to say, I hope, is it, that, I mean, this legislative background is summarised very helpfully in your skeleton argument, and I take it, you know, if we lose sight of the wood for the trees, we can remind ourselves how it all works by reference to that. Or is there anything really important you're telling us now, which isn't it already in the skeleton somewhere?
No, this court already has the key point I was seeking to make, which is when goods go across a border, that changes both the place of supply rules and the VAT classification of the supply of goods. It doesn't actually matter whether they're excise goods or not for my purposes. I simply wanted to be accurate. When we are dealing with excise goods, there is a wrinkle in the legislative regime. But
not a material wrinkle.
Not a material wrinkle.
Well, we can probably leave the wrinkle on one side.
Sorry, and your two key points are when goods cross the border. First is the change of the place of supply, and secondly?
The VAT classification of the supply of goods, full stop. So it becomes an exempt supply, and it gives rise to a separate chargeable event, which is an intercommunity acquisition in the United Kingdom. So ordinarily, you would simply have supply of goods, standard rated, receipt of goods, ability to claim input tax if you're the customer, and you're a business and you're VAT registered. Once you move goods across a border, because the whole purpose is to shift fiscal responsibility from one member state to another, and the benefit of the tax receipts to the subsequent member state of receipt, the purpose behind that, therefore, is to move the VAT on. And consequently, the supplier in another member state is allowed to claim its input tax but doesn't charge output tax. It's an exempt supply, treated in the UK as zero rating. And in the United Kingdom, it becomes a chargeable acquisition of goods upon which VAT has to be paid by the recipient. And so what becomes important is to identify the recipient of the goods, because that is the person to whom a chargeable event is attributable.
And zero rating is described in the community legislation by this rather misleading concept of exemption together with, what it is, sorry, with
refund.
Thank you, with refund, yes.
That's to distinguish it from what I would call the social zero rating. So, for example, books,
yes,
train fares, etc., which are or medicines, which are all subject to there's a social policy justification for them.
Thank you.
And there are retention from previous legislation before we joined. Right. So that, I think, is all I need to get.
I'm not saying we won't come back to it, but I'd just like to anchor it a bit.
I may well need to. I can well
Actual
understand
hypothesis.
my Lord's desire, if I may say so, to understand where this is going. And with that in mind, I will adjust my submissions accordingly.
Thank you.
Now, ground one essentially contends, we say, that the Upper Tribunal at paragraphs 49 to 50 inaccurately set out the Commissioner's case. And what those paragraphs said in terms was, the Commissioner's case was that there was a sale of goods.
Shall we go to it?
Yes, please. This is in Core Bundle, tab 7, page 68. We see this section begins how HMRC put its case in pleadings. There's an extended reference to the amended statement of the case. It doesn't refer to the further and better particulars. It then says in paragraph 50, as regards the purported French customers, HMRC's pleaded case was that the customers were mere buffers or conduits, whose purpose was to give an appearance of an in-bond transaction, and thus to facilitate the movement of the goods to the UK to be sold by or on behalf of the ward. So, in fact, it was suggested that we had, in fact, sold these goods into the United Kingdom, or that the goods that had been sold in the United Kingdom were somehow sold on our behalf by some
Yes,
sort of seller.
I think it's not sold into the United Kingdom, is it? I mean, I would read that as the movement of the goods to the UK to be sold by or on behalf of a ward, i.e. they were sold in the UK, having been moved to the UK.
Oh.
That's how, I mean, that's...
If that's how my Lord reads it, then
I personally do, but
that's how it was intended
rather
to be
than...
put. But
I'm sorry, I haven't got this passage.
Oh,
In 68,
50,
did you?
it's in-
page 68,
Oh,
paragraph,
page 68, sorry.
paragraph 50.
what you did was to refer to 49 very briefly as being the lead-in
Yes,
to
thank you.
50. I mean, the whole of 49 I read as being concerned with a Ward's case, that these were sales in France. And then, and what HMRC says about that. And then, as you say, 50, well, they say there what they say.
Yes. And it was in the light of, I mean, that has been part of the way that the case was phrased from the off. But if I could take you to the assessments first, perhaps, we can see what the actual grounds for the assessments were, and then how the case was nonetheless modified as a result of a statement of case being raised. So if we could start, please, in the supplemental bundle this time, tab 1, page 12. If I can put it this way, the assessment is raised on the basis of what's sometimes called an unexplained cash case. So page 12 says, notice of VAT assessments.
Sorry, I'm still not with you.
Supplement-
Tab 12.
No, my lord, sorry, tab 1, page 12.
Tab 1.
My fault. Tab 1, supplemental bundle, page 12.
Got it, thank you.
So notice of VAT assessment dated 30th September 2014. And the officer says, I believe that you have not declared or we have not assessed the correct amount of VAT due for the period shown below. This is because monies have been deposited in the UK for the sale of goods said to be made in non-UK bonded warehouses, and the money is said to be transported into the UK by cash couriers. However, subsequent HMRC checks reveal this scenario is not credible, and the monies must have had a UK origin. So the case that is being put is essentially, well, you've got these monies appearing in your bank accounts. They are monies that are being cashed in the UK. We don't accept that they are in relation to transactions taking place in bond in France, therefore they must be transactions in the UK. So it's an unexplained cash case, as one sometimes sees in the old-fashioned Section 60 cases involving takeaway restaurants or dry cleaners who have suppressed their takings. Recourse is made to the bank accounts. The bank accounts show receipts of substantial sums of money above those declared. Therefore, it's said there's been an under-declaration. That's essentially how it's being put. and then one sees bundle 2, tab 29.
So that's
Supplemental bundle, tab 2, page 29. So much easier virtually to get the references right.
Oh,
You
dear.
simply say the page.
Well, don't say that, please.
Page 29, we see exactly the same basis. It's an unexplained cash case. So the assessments are being raised on the basis that origin of cash.
Yeah.
Why is that significant? Well, there are certain other transactions where it was accepted that payments for the goods had been made by way of telegraphic transfer. It was possible, therefore, to identify the origin of the goods, the origin of the money, and therefore there was no issue taken with the supplies not being UK vatable supplies. And one sees that at tab 3 of supplemental bundle, page 32. And what this document dated the 23rd of December 2015 does is reduce the value of the assessment in respect of certain transactions. And the officer says, I've now arranged that these assessments will be reduced, leaving only those transactions where HMRC consider that the origin of the payments has not been sufficiently evidenced. So what it's concerned with is where is the money coming from? It's unexplained money case. HMRC, it says, does not offer a positive case that transactions which have been excluded from the computation were legitimately made. The details of this reduction are given in the attached schedule. So whilst they're not saying, yes, we positively accept that all of these transactions are valid, nonetheless, no objection is taken to them. And they don't feature in the assessment. Now, we say, whilst there is no positive case, no positive endorsement being given, the position simply is this. Those transactions which are paid for by electronic transfers are recognised not to give rise to supplies of goods in the United Kingdom, because otherwise tax would have been said to be due on them. And my client's evidence, for better or worse, was that there was absolutely no difference between those transactions and the cash transactions.
See, they were recognised, just repeat what you said.
They were recognised to be not to be transactions which represented sales of goods in the United Kingdom. Why do I say that? Well, because no assessment to VAT was made for them. They were struck out, they were taken outside the scope of the assessment.
Yeah.
So in circumstances where my client's case is, well, look, I've set this company up specifically. The director behind my company, the former director behind my liquidated company, has other companies. And they do business in slightly different ways, and they've been subject to certain VAT proceedings, one of which is coming before the Court of Appeal in due course, where we were successful in the Upper Tribunal. But putting that to one side, the point is my client's case has always been, this company did business in the following way. It did business under bond in bonded warehouses in other member states, principally France, Belgium, Netherlands. And the commissioners have necessarily accepted that business when the money origin is capable of being tracked through to an identified account. So where there is a full audit trail available because electronic transfers were made, that version of events was accepted. Now, the commissioners then filed a draft amended statement of case. We don't have that initial draft. What we do have is a letter that accompanied it from HMRC to the Courts and Tribunal Service. That is at Supplemental Bundle tab 4, page 34. And in the second paragraph on that page, the author, Miss Barnard of the Solicitor's Office, says, paragraph 2 by the second whole part, first, HMRC filed its draft amended statement of case on the 7th of April 2017.
Just getting this open. So it's page 34.
Page 34 of tab 4.
Yeah, and oh yes, I see.
So that simply gives
So this is its this is its sort of I mean, you filed your statement of case.
we'd filed grounds of appeal.
Grounds of appeal, right? And this is their response, as it were.
Yes, a complaint is made, not without some degree of merit. The grounds of appeal were rather short.
Oh, yes.
So it is. They were tab 2, page 24, for example.
Yeah.
Mr. Jones showing his concise nature. Paragraph 3, for example. Each assessment is pregnant with the assertion that the appellant has sold goods and traded within the UK, but declared that the traded goods were traded outside the UK. Each such assertion is wrong. So in terms of what we were putting in issue with the assessment, we were saying, well, these are based on the allegation that we've sold goods in the UK or traded in the UK. That's simply not right.
Yeah.
Turning back, if I may, to page 35. As I've said, we don't have a copy of the original draft. It was overtaken by amendments that I'll come on to. But we can see how HMRC was putting its case at this stage. Page 35, 10 or so lines down, there's a sentence that begins, as Helen Barnard's witness statement made clear. If the court has that, I'll read on.
Yeah.
As Helen Barnard's witness statement made clear, fraud, dishonesty was clearly pleaded in the statement of case at paragraphs 9, 13, 17, 18, 40 subparagraph D and 21. The appellant's skeleton fails to acknowledge that fact, etc. We then move on. The appellant, ignoring that plain fact, now seeks to recharacterise the draft amended statement of case as a new case. That is simply false and amounts to an attempt by the appellant not only to object to HMRC's clarifications, but is seeking a ruling from the tribunal to effectively expunge that originally pleaded case of fraud entirely. That is unacceptable. HMRC has pleaded a case in fraud and will pursue that case at trial, and has made its suggested draft amendments in response to the appellant's alternative application made on the 9th of November 2016. So the case at this stage was being run as a fraud case. One then sees by the second hole punch a sentence that begins, the more fundamental difficulty with this, I shall read on, the more fundamental difficulty with this is that it proceeds on the basis that no fraud allegations were pleaded in the original statement of case as set out above. Such a case was pleaded in paragraphs, etc. The appellant was required to give disclosure by reference to that pleaded case and file witness evidence in response. So the clear assertion is being made that HMRC are here running a fraud case. That would no doubt, following the usual contours, be you were knowingly involved in somebody else's fraud or participated in a fraud, or you took part in transactions where you knew or should have known that the proceeds of these transactions were part of fraudulent activity. Standard basis. See a summary of the specific allegations when one looks at a decision of the tribunal on an interlocutory skirmish. That decision is a decision of Judge Jennifer Dean. It starts at page 37, behind tab 5. If we could pick it up, please, at page 38, one sees in paragraph 1, 2 separate applications were being made. The first was Mr. Jones' attempt to have HMRC barred from any further part in the proceedings. That was rejected in the course of this application. The second was that HMRC be required to amend its statement of case so they can set out, based upon which it said that the appellant's suppliers should be subject to UK VAT. And that was based on an allegation that the way that the commissioners were pleading things hadn't identified a proper basis for the UK assessment. That particular application was basically held in abeyance because Miller and Friend for the commissioners applied to amend the statement of case. I'll come on to that in a moment. For present purposes, please let the court read paragraph 2, which sets out in summary form the nature and extent of the allegations that were being made at this stage. The complaint that's being made on my client's behalf by counsel, then instructed, was that there were a bunch of inconsistent things being pleaded in the case. So it said on the one hand you'd be making supplies goods in the United Kingdom, implying a physical supply delivery in the United Kingdom by my client. on the other hand, it was recognised that there had been these transactions taking place in EU warehouses, and it was said that there had been an inward diversion. So that would be contrary to the suggestion of a delivery and sale in the United Kingdom. It would suggest that there was a cross-border element to the movement of these goods. Now, in terms of what then happened, at page 42, we see a summary at paragraph 11 of what was said to be the modus operandi adopted by the appellant. So at this stage, the modus operandi that's being identified is part and parcel of a fraud in which it is said the appellant is involved.
Sorry, this is paragraph.
Paragraph 11,
11.
line 30. If my lord would be kind enough to read all of paragraph 11, it sets out, again, the gist of the allegations that are being made. The important thing is it is positively asserted that this alcohol is held in a French bonded warehouse. How it gets to the United Kingdom is then the subject of an allegation that it's part and parcel of an inward diversion fraud. And we can see that also at paragraph 18 at the bottom of page 43. HMRC positively contends that the appellant received and or banked, the monies the appellant received and or banked in the UK is the consideration for the goods purportedly sold in bond to French buffer companies and from them to the purportedly genuine French traders.
Sorry, which paragraph is that?
My lord, this is paragraph 18.
18, thank you.
Bottom of page 43. Top of page 44. HMRC contends that while the supply chain is arranged to appear as though genuine taxable transactions are made in France, the monies received by the appellant is in fact the consideration received in respect of taxable supplies in the United Kingdom. That involves detailed questions of fact cannot be resolved a strikeout application. So the goods are necessarily coming from France to the United Kingdom, and it's being said at this stage that there are taxable supplies in the United Kingdom by the appellant.
Yeah.
That isn't dealing with money, that is now moving on to transactions. And one can see how if, for example, a trader were pulling the strings on an inward diversion fraud, such that it seemingly said it was selling to French buffers, but that was all a sham, and in fact it was delivering the goods directly to a cash and carry somewhere in Romford, and the goods were being slaughtered en route or delivered to a cash and carry under false pretences, then there would in fact be a physical delivery by my client to somebody in the United Kingdom. Yeah. But of course, the consequence of that would be that there had been, absent the allegation of fraud, there would have been a physical delivery of goods by somebody based in France to the United Kingdom. And if that somebody in the United Kingdom receiving them is a cash and carry, that would be a business. And the cross-border movement rules would treat the taxable supply as an acquisition by the cash and carry. And the supply by my client in France, even if it was part of a fraud, would properly be characterised as an exempt supply for VAT purposes. What would unwind that analysis would be an allegation of fraud on the standard cartel basis. So that would be the technical VAT analysis of what was going on. But if it's right that my client was taking part in the fraud, it would be open to the commissioners to say, well, you're taking part in this fraud, you knew or should have known, or indeed you were doing the fraud yourself, and therefore you can't take advantage of the EU rules to your advantage, and somehow therefore you are liable for the output tax on what should be treated as a purely domestic sale. That would be one way of arguing it. So you would basically suspend the application of the normal rules to deal with the fraud. There would be arguments as to whether or not the cartel test enabled you to do that, but that would be one way in which it would be articulated. That, however, is not where we ended up. We see then at page 48, paragraph 32, but suffice to say, Mr. Jones's attempt to have the Commissioner's participation in the appeal stayed did not meet with success.
What is called an ambitious application.
Well, it's not for me to say that, my lord. I'm not going to spend minutes debating the issue.
No.
Page 48, paragraph 32. My learned friend, on the second part of the application, when we were saying, please can you give particulars, my learned friend said at the oral hearing, Mr. McGurk orally applied to amend the statement of case. Draft amended statement of case had been served on the 20th of March. There was a direction to serve it by a certain date. That direction wasn't complied with. I make no particular complaint about that. It was then complied with, and so the entire matter was stood over to be determined in due course. It simply wasn't dealt with here. We do see, however, at page 52, paragraph 44, Mr. Jones's submission that the statement of case was poorly worded and painted a confused picture met with more success. However, the learned judge did not consider that undermined HMRC's case to such an extent that they should be effectively debarred from defending the appeal. Page 53, paragraph 46, line 5. As regards the issue of fraud, again, I agree with Mr. Jones QC that as at present, although raised as an issue, it is not particularised to any great extent, for instance, by sending out the details of the transactions in which the appellant was involved. However, for the purpose of this application, I've concluded HMRC's case is not a fanciful one. So it was being said, basically, the battle about whether or not the statement of case needs to be amended and the particular of the fraud to be given will be dealt with at a future juncture. Now that future juncture arose, I think, in the course of the first day of what was meant to be a substantive hearing of the tribunal itself, the tribunal hearing itself. One can see that tab 8, the supplemental bundle, page 90. And this is a letter written after the court skirmish has taken place the day before. So the hearing had been listed for a 5-day trial, I think, starting on the 8th of May. This was a letter written by Ms. Barnard on the 9th of May. And please could I invite you to read paragraphs 2 to 6 of the letter.
Yeah.
So having said that the case was fraud and they would plead it, we've now had something of a reversal of that position in that it's being suggested their case has never been about fraud, It's simply that we were caught up in somebody else's fraud, and that inward diversion fraud took place, but no allegation of fraud was being made against us. Instead, it was being suggested simply that it wasn't accepted that our customers reflected genuine transactions by us to them, but nonetheless it wasn't being suggested that we somehow knew or should have known of that fact. So we end up with this rather curious position where having been run as a case of fraud, it no longer is being run as a case of fraud, but also some important points are coming out. Firstly, it's accepted that the relevant transactions involve a supply of goods that originate in France. And that has always been the Commissioner's case. What they say is we don't accept that the supplies of goods to the customers that you say you had in France were in fact supplies for VAT purposes in France, because the French customers never made any payment to us. Those payments were received from other parties further to the supply of those goods in the UK. So just pausing there, what that means is that there is a chain of transactions taking place. It's not just the purported supply from us to our customers. There's also a supply of those goods in the United Kingdom. So the question becomes, well, who do you say is making those supplies of those goods in the United Kingdom? And who do you say that the other parties who are paying for those supplies are? Because, of course, that's crucially important to understand on what basis it is being said there is a taxable supply by my client, the appellant, in the United Kingdom. And so, understandably, this particular letter...
So the first question you take is, who is making the supply in the United Kingdom?
Yes.
And secondly...
who's paying for it? Well,
who
it's received from other parties further to supply of those goods in the United Kingdom. So there is a transaction that is taking place.
Yes.
That is not a transaction in France.
Right.
What are the parameters of that transaction?
So, yeah, not quite sure I understand that actually. We would say the parameters of the transaction.
This is necessarily quite a truncated piece of exposition as to what the Commissioner's case is.
Yes.
What we then see in their amended statement of case is a much more detailed version of events. So perhaps it's as well if I just move on to that. That's tab 9, page 93. And one sees that the statement of case has been amended, and in the standard way the amendments are shown with underlining. HMRC says in paragraph 1 at page 93, for the avoidance of doubt, HMRC contends that the monies lodged in the appellant's UK bank accounts relate to taxable supplies made for consideration in the United Kingdom. Now, that doesn't in fact say are the result of taxable supplies made by the appellant for consideration.
What about the previous sentence?
So, HMRC made various assessments to VAT in respect of goods which they consider the appellant has sold or traded within the United Kingdom. But in fact, the assessment said we're basing this on the origin of the monies.
Yeah, but they're saying, I mean, that's their case here, isn't it? And then the next sentence you refer to is said to be for the avoidance of doubt, and that the monies in the appellant's bank accounts relate to supplies made in the UK.
So, my lord, I accept at face value that could be the way it's being put.
Well,
So,
one has to credit HMRC with the knowledge that they can only levy VAT on transactions made by the taxable person in the UK.
yes.
I mean, this is not an exercise of interpretation in the abstract. It's one where both sides know perfectly well what the ground rules are.
Well, one would hope that.
One would hope so.
Yes. We then see in paragraph 3, at the bottom of page 94, that the supply chains have been traced to tax losses. Now, what that shows is HMRC are relying on material available to them, which shows a chain of transactions leading back to what is said to be a tax loss.
So you're in paragraph?
Bottom of paragraph 3,
Yes.
page 94.
I see. And HMRC contend that the deposits relate to taxable sales of goods made by or on behalf of the appellant in the UK.
Yes, and that is relatively clear, isn't it?
I would have thought.
It's suggesting that you have physically delivered goods in the United Kingdom for cash. We then see, however, at paragraph 7, and onwards. Recognition that the goods in question must necessarily have come from France, because the commissioners go to great lengths to explain how inward diversion fraud works. And one sees in paragraph 8b, page 96, diversion is being described as the use of ARC numbers, which a particular reference system for intercommunity movement of goods under the EMCS. Documents for the purpose of showing a purported duty suspended movement of excise goods from another member state. In fact, the ARC number in the documents are used more than once to bring more than one consignment into the UK, and the extra consignments are diverted to the UK market without payment of the duty. So what's being said is there was a system put in place whereby somebody would have on its face a legitimate transaction moving goods from France to the United Kingdom. It would be given a reference number under a computer system. The goods would then move under that reference number. And if they weren't stopped or checked by customs, another mirror load would then follow it, use the same ARC number, and so on, until such time as the due date for expiry of that reference number was reached, or a particular load was stopped. That is how it was said that the fraud was working. We then see paragraph 9. It said that the transactions with which we were involved, the supply chains we were involved with, were all the hallmarks of inward diversion. And it's also said, for the avoidance of doubt, HMRC do not accept they were customers in the sense of being parties who received a taxable supply at all, and or insofar as they made no payment for those alleged supplies. So again, it's being suggested that you didn't in fact receive cash from your customers, and that they therefore weren't customers for those purposes. We then see paragraph 10, a contention that all of the stock, at 10b, all of the stock is said to be held in bond in other member states, and that we contend those goods never enter the UK. That's in the context of our dealings with them. And at 10e, it summarises our case that the majority of our customers pay by telegraphic transfer. Of course, those are the transactions which aren't contended to be anything other than not UK taxable transactions. We then see, however, that it is being recognised that there are necessarily goods in France. One sees that at page 100, paragraph 13 and 14. Please could the court read 13 and 14. And then at 15, we see an explanation of the method of the fraud, the double run, the mirror deliveries, etc., which I've sought to explain. What's being alleged here is these goods originate in France. They benefit from the arbitrage potential of the differential duty rates that I've identified. They're being smuggled over. They're using a system which enables them to avoid detection under the electronic movement system. And the consequence is that these goods are ending up being delivered for supply on the open market without proper duty being paid and without VAT being properly dealt with either. That, in essence, is the way that the case is being put in terms of the underlying mechanics of what's going on. And at 17 and 18, we see further particulars of that where it's reference being made, for example, to one of the goods having been stopped, and the customer in question, Scorpion in London Limited, says that the goods were supplied to it by my client via a bond based in two bonds based in France. And so the underlying allegation here is that Scorpion in London Limited has brought the goods in using its own haulier, the goods have been purchased from a French bond. That French bond, two French bonds, were where my client's goods were held. They were then moved to a third French bond, which was to Scorpion's account, and from that account the goods are then moved under what was no doubt purporting to be duty suspension arrangements, but they were stopped, found to be non-compliant with the duty suspension arrangements, and the goods were seized. What's said from this is not that we were involved in that fraud, but that it shows that our transactions were linked to those who were involved in or linked to fraudulent diversion of alcohol in the United Kingdom. That's paragraph 18. We then come on to the meat of the substance of the case. I'm afraid it's quite a long section, but it is quite important for setting the scene for the request that we then made on the basis that the case was put. So could I try the court's patience and invite you to read paragraphs 37 through to 43, page 109 to 1112 of this document. I'm afraid it's 3 pages worth of text. Right. So if one looks at the bottom of paragraph 40, page 111, by the second whole page, the gist of the case at this stage is that the funds received by us arise upon the sale of goods once diverted into the United Kingdom. So it's said that the transactional documents as between the appellant and those from whom it claims to receive payment are arranged to give the impression of taxable supplies being made in France. And that comes obviously perilously close to suggesting that we are involved in the fraud. But of course, it's part of HMRC's case that you are not involved in the fraud. But what's being said is there are transactions in the United Kingdom upon which money is paid.
Well, sorry, you just said it was part of HMRC's case that the appellant was not involved in the fraud. I mean, is that actually quite right? Isn't it more they're not alleging that they were involved in the fraud?
But no, they've
It's not, is it positively their case that you were not involved in the fraud? Or just we're not alleging it?
Well, they're not alleging it. If they were alleging it, they would be duty bound, obviously, to
Yes,
prove.
Yeah.
but they're not positively saying you weren't involved. They're not positively saying you weren't involved in the fraud.
So this particular tension is the tension that then leads to us asking for further particulars.
Yes, I understand
Yes.
that.
I mean,
That I
this is always a problem in this kind of case, isn't it? Because you get the taxpayer jumping up and down and saying you must allege fraud with full particularity, etc., etc. And then the revenue say, well, actually, we don't have to do that because you have to displace the assessment. And furthermore, in cross-examining your witnesses, we're perfectly entitled to put to them points which are would be compatible with you being involved in the fraud.
Yes.
I mean, that's what Brady establishes and other cases since then. And I mean, this is a difficult position to get one's head around, but it is well established and does often, in my experience, lead to misunderstanding. I mean, often on both sides as to what the true nature of the position is.
At this stage, before this court, I'm not seeking to suggest that you shouldn't follow Brady because of the observations of Lord Justice Carnwath in 2006. In one of the Section 60 cases, I think it was. But suffice to say, I would like to reserve my position in due course should we go further.
Yes.
But yes, at the moment, I accept that in seeking to challenge an assessment, the burden lies on us. I may have observations to make if the matter goes further as to whether or not that approach in a VAT context is appropriate given EU law principles of effective protection of EU law rights. But I shan't weary you further today with any detailed submission on that point. I simply wish to cast down the marker, if I may. My position is reserved should it go higher. But there is a more fundamental point here. Ignoring the parameters of the are they alleging fraud, are they not alleging fraud, does it matter debate, there is a fundamental issue as to what is the actual transaction that is being pinpointed. And of course, one would be expecting to see an allegation that basically everything that takes place before the physical delivery of goods in the United Kingdom is smoke and mirrors. That, it seems to me, is the import of what is being suggested here. And if that's right, then it seems to be being suggested that because our transactions with our customers were shams, or smoke and mirrors, in fact, it's us that is therefore making those supplies into the United Kingdom, and we are receiving the money for it. That's how I would read the amendments to 40, page 111. And of course, we know that in fact, the people who have arranged for the dispatch of the goods are not us, because we no longer had them. So that raises the question in my client's head, well, how on earth are you saying that we have supplied these supplies, we no longer had them? They had been transported by other people, and you say that we're not part and parcel of that fraud, therefore we are not involved in it. And we see back at page 110, paragraph 40, there are certain constants. So this alcohol, these excise goods, is French alcohol, hence the arbitrage opportunity. There's then a purported sale, and it's not accepted that the sale took place. The indications are, see subparagraph D, that the supplier of the goods or the purported French customer divert the alcohol back into the United Kingdom. Now, just pausing there, what that doesn't say is you've diverted the goods. You've dispatched the goods yourself into the United Kingdom for sale there. That isn't what's being said. And so it's ambiguous. Are you saying, you're saying we're responsible for the tax-free transactions, but are you saying that we delivered them and that we therefore delivered them to a customer in the United Kingdom for the purposes of sale of goods? Moving on, at paragraph 51 and 52, it said HMRC, bottom of page 114, said HMRC regards as implausible the claim that the appellant has undertaken a legitimate trade exclusively through legitimate French customers. Again, that raises the question perhaps of whether that's fraud by the back door. And then at 52, one sees the receipt by the appellant of sterling into its bank accounts is more plausible and consistent with the receipt of the proceeds of sale of goods sold in the UK. So that's going back to the origin of the money point.
Sorry, where is that? Just for you.
That's 52, top of page 115.
Oh, yes.
So you bank these sums in the UK, therefore the sale of goods in the UK. And that can happen even if the customer's made a further sale of those goods to English end customers. So it appears to be recognised that there has been somehow more than one sale in the United Kingdom, but it's unclear what the transactions are. And as I say, that element of confusion and perhaps some sort of concern as to, well, indeed, it was a concern that somehow fraud was being pleaded by the back door. That concern led to our request for further and better particulars. And the response to that can be seen behind tab 10, page 116, the supplemental bundle. Starting in paragraph 1, it confirms that it's a response to a request we made for further and better particulars received on the 15th of May. Bottom of page 117, paragraph 5, HMRC say, for the avoidance of any doubt, HMRC has set out a detailed defence and made it clear no case of fraud is being pursued against my client. That's a reiteration. We are not alleging fraud against you. At the bottom of page 119, one comes on to a series of requests and responses that we say importantly narrow the issues between the parties and represent concessions as to the state of play by the commissioners. The first one starts at page 119. And the request is made in respect of the assertion that for the avoidance of doubt, HMRC contends that the monies lodged in the appellant's UK bank accounts relate to taxable supplies for consideration in the United Kingdom. So we then have a request, whether this says it refers to all and any monies lodged and so on in respect of each and every lodgement of monies, particularised by whom and when each such taxable supply was made. So why are you saying that these are taxable supplies? Ben said the assessments were raised on all cash and cheque payments. Assessments were not raised in respect of sums received by electronic transfer. So again, where you have a similar fact pattern of supplies of excise goods that start in France that are attributable to an electronic transfer, that doesn't give rise to the concern. Where you've got cash being banked in a UK bank, it does.
And the cheque payments too.
And the cheque payments too, sorry. Incorporated the two. Yeah. Paragraph 2 then says HMRC does not know the identity of those who made the taxable supplies in the UK, consideration from which was paid into the appellant's UK bank account. Nor does HMRC know the time of those sales, other than the consideration from those sales must have predated their deposit in the appellant's bank account. That seems to be suggesting somebody else has actually made the sales of the diverted goods in the UK. The consideration from those sales has been tracked back to my client, and therefore we will treat your client as the one making the supplies. That's, I'm afraid, how I would read that assertion of what is being said. And it then says HMRC positively avers the payments were not made by the alleged French cash and carry customers. Well, that is a positive case that is being put forward, but it doesn't tell you what are the transactions that you say took place on UK soil that give rise to output tax.
And that, on the face of it, is not something you'd expect HMRC to be able to give chapter and verse, is it? I mean, it's really for your clients to come up with an explanation as to how this money ended up in their bank account, from which the obvious initial, the first blush inference is, well, of course it's in your bank account because it's part of the turnover for supplies that you made.
But HMRC didn't say, this is unexplained cash, you tell us where it's come from. What they said was, this is cash that has come from transactions that result from inward diversion fraud of excise goods. And we've looked at the supply chains, and they trace back to you. And those supply chains trace back to unexplained losses. So they've gone the extra mile and said, this is how this has worked. This is the modus operandi. Saying we're not alleging fraud, but this is the modus operandi. And they say French goods, French excise goods, French beer and wine, spirits, based in France, smuggled into the UK, gives rise to transactions in the UK, you receive the money for them, that's a UK transaction. That's what's being said. And one can understand that as an argument. The question is whether or not, as a matter of legal VAT analysis, it's correct. And that, you know, the appeal that we make is by reference to the way that the commissioners necessarily put their case and confine their case is a concession as to the factual matrix in which these transactions took place. Now, I accept it's unsatisfactory that we don't have the transaction specifically to look at. My client's position is an evident one, which is he has put forward an account of who he said he was dealing with that hasn't been accepted. But ultimately, my client was not selling goods from a warehouse premises in Romford for these purposes. These are excise goods that started in France. And the question is, how did they get to the United Kingdom? And that's what we then come on to look at. So we then see at page 120, request 2, supply chains have been traced to tax losses, and HMRC contend instead that the deposits relate to taxable sales of goods made by or on behalf of the appellant in the United Kingdom. We then say identify each supply chain to which this averment refers. If it's alleged that taxable sales of goods were made in the UK on behalf of the appellant, identify by whom and when such taxable supply is alleged to have been made. The answer comes back, this is disproportionate. In any event, the appellant does not need to know the precise particulars in order to understand the case advanced, which is that goods that the appellant contends were supplied to the alleged French cash and carry customers were in fact the subject of taxable supplies in the UK, the consideration for which was paid to the appellant. Now that has to refer back to the fact that HMRC, see paragraph 2, does not know the identity of the person who made the taxable supply in the UK.
Well, but they're said to be made by or on behalf of the appellant.
Yes, and so the next stage of the analysis is, what do you mean by that? Are you saying that these were sold by people in the UK who we can't identify, but they were your selling agent? You know, is that what you're saying? Are you saying that, yes, we supplied...
Well, I would have thought. I mean, on the face of the language used, the answer to that must be yes.
So we'll come on...
But let's see how that develops.
We will. And it then says, without prejudice to the generality of the foregoing, the supply chains are those involving goods purportedly sold, which are claimed to be cash and carry, which include those listed, etc. It then says, next response, HMRC cannot and does not need to identify the person who made the taxable supply in the UK or the date on which it was made. So there is a taxable supply by person or persons unknown.
Well, the allegation of which this is a request is that they were sales of goods made by or on behalf of the appellant. So, I mean, there's no doubting the allegation who the seller was. So the query must be as to the identity of the person making the supply on behalf of the appellant. Because, I mean, there's no ambiguity, is there, that the appellant was the seller.
Well, there is, because...
Well, no, because the allegation is that they were sales of goods made by or on behalf of the appellant.
But there is a taxable supply, which is a separate supply of goods by somebody else who has not been identified.
No, hold on. That's not what it says. It says that they were sold by the appellant in the UK, either itself or through an agent.
So what is being said here, however, is HMRC cannot and does not need to identify the actual person who made it.
Well, that's to say, can't identify the agent.
Well,
I mean, if it had simply said relate to taxable sales of goods made by the appellant, there'd be no information that you could request, because the allegation is you made the sales. You might say, when did you make them? In which case you could say, well, we don't know. That's what they come back with. But where you say, I mean, by saying identify by whom they were made, that can't mean, are you saying it's by the appellant? Because that's actually what they plead. Well, the request must relate to the agent.
Well, what they're saying is they're made by or on your behalf.
Yes.
Because you received the money for them.
Well, no, sorry. That, yes, okay, that's the evidential basis for the assertion, but the assertion is that you sold the goods.
Well, we'll come on to see.
I mean, anyway, that's how I'm not surprised by the answer. We don't know who made the sales, in the sense we don't know who the agents were.
Well, my lord, if that's the way it's construed.
Well, why wouldn't one construe it that way? That's what I'm.
Well,
anyway, there we are. You have my point on it.
A number of reasons, not least that we asked specifically about the agency point.
You asked specifically what?
About the agency point. So we come on to...
Well, you did in here.
Yes.
Here on page 120.
Well, and also...
If it is alleged that taxable supplies were made in the UK on behalf of the appellant, identify by whom it is alleged to have been made. So that's the question is, who is the agent? And they say, we don't know.
My Lord, my submission is it doesn't actually say that. What it's saying
Well,
is we don't know who's made the
sorry,
taxable
I mean,
supply.
how do you construe the opening words of request 2? If it is alleged, which it is, that taxable supplies, sales were made on behalf of the appellant, identified by who? That must be a question relating to the agent.
Well, if that is right, then it's true that they haven't identified the specific transaction.
And they can't.
No.
No. They haven't identified the agent or the transaction.
Yes.
But the assertion, the basic allegation remains that you were the seller.
Well, I suppose what this shows is that there's a disjunct between the concept of the person who is making a taxable supply in the UK, which would be the agent,
Would it?
and
Would it? Is that right?
well, it would, my lord, because the goods have crossed a border.
But they're here. They belong to the appellant, and an agent is making a sale on behalf of the appellant.
Well,
Why is the appellant not the seller?
because, my lord, the goods have moved across a border, therefore there's been an inter-community removal of the goods from France.
Yes, but not a sale.
Well, it would still be a supply, my lord, because the
You know, I've got goods
yes,
in France in a warehouse. I move them to a warehouse in England. They're still my goods,
my lord,
and I, through my agent in England, sells them. Isn't that a vatable sale by me?
yes,
Isn't that what they say?
no, because
Well-
they then come on to say,
But just focusing here, as I say, anyway, there we are. You've got my point. It seems to me that question 2 is clearly asking who the agent was.
well, my lord, if that's right, then there's been an inappropriate reference to a taxable supply. Because they shouldn't have said, we can't identify who made the taxable supply. They should have said, we can't identify the agent.
Well, that's what the question is to be, or was, who is the agent? Because just look at the premise of 2.
Yes, no, my lord, I've seen that.
Yes.
And
So it's saying, if we put it shortly, identify the agents. That's what it's asking, isn't it?
if it is alleged that the taxable sale of goods was made in the UK on behalf of the appellant, identified by whom and when each such taxable supply is alleged to have been made. Now, what they actually say is not we can't identify the particular agents who made the taxable supplies that you made. They say simply we can't identify the person who made the taxable supply.
Mr. Beale, that's
Well,
all right.
it's perhaps
Even we have to laugh sometimes.
there we are. I'll do the best I can. Could I then please invite you to look at top of page 123. And we see the extent to which it's being said. So again, let's rather than shortcutting to the answer, lest it be said that I haven't understood the context in which the question is being raised. Let's just look at the question. So firstly, the assertion is HMRC consider that these continuing payments relate to taxable supplies made in the UK. So you've got ongoing payments. And then the request is in respect of each of the continuing payments, when and by whom the taxable supply in the UK is alleged to have been made. The avoidance of doubt, whether all of or any of the persons, firms or companies given in answer to 11 above are alleged to have been acting as agents for the appellant. It then says the continuing payment is a reference to further cash and cheque payments the appellant received from alleged sales into its French cash and carry customers. And then over the page, top of page 123, HMRC's case is that the appellant's goods were only sold for consideration in the UK, and that consideration was what comprised the deposits in the UK bank accounts. Those supplies were, to that extent, made on behalf of the appellant. So what's being said is there have been sales that have taken place, you've received the cash for them, and therefore, to that extent, they are made on your behalf. What they don't identify is anyone actually acting as our agent in transactions in the UK.
Well, they can't, and they I mean they say they can't, and they don't have to do it.
Well, my lord, they do, because we have handed the goods over to other people. And
That's what you say.
Well, other people. It's accepted that other people are responsible for moving those goods into the UK, and we'll come on to look at that.
Okay.
So we then see page 124. It says, of insofar as the goods are purportedly sold in France, excise duty and VAT would become payable. That's a technical point which is being picked up upon, which is if in fact you do have duty suspended sales of goods in France, excise duty wouldn't be payable. VAT may or may not be payable depending on the type of warehouse that the transaction is taking place. So it's a recognition that if there are in-bond sales, there wouldn't in fact be excise duty payable on those transactions. Then moves on to say, in fact, the indications are that the supplier of the goods or the purported French customer divert the alcohol back into the UK under a cover of a single ARC number, which is used on more than one occasion to facilitate inward diversion. So the allegation that's being made there is that somebody who is identified as the supplier of the goods, or alternatively is identified as the purported French customer, is the one who diverts the alcohol back into the UK under a movement of the goods, purportedly under a duty suspense arrangement. So what is then requested, specifically under 2 at the top of page 125, is it being suggested that it's the appellant that is the supplier to whom reference is being made here? Are you the supplier of the goods cross-border? Are you the one that is physically dispatching the goods to the UK where they're sold allegedly on your behalf? If not, are you saying that the supplier of the goods was acting as our agent? So is there an agency relationship with the person who has physically dispatched the goods? French customers we can park to one side for the moment. The response at paragraph 1, page 125, is that the basis for the plea of inward diversion was not made against the appellant because it didn't need to be, and it was particularised in the amended statement of case. It said that the witness evidence explains how the inward diversion is being operated. Again, it's not being suggested that we were party to that inward diversion fraud. The supplier, it's said, of the goods is not a reference to the appellant, but a reference to the appellant's own supplier. Then, HMRC does not allege, does not need to allege, that the supplier, as explained, is the appellant's agent as regards the inward diversion of the goods to the UK, which it originally supplied to the appellant. There's then detail on the French customers. Again, for the avoidance of doubt, HMRC does not contend that these French cash and carries were acting as agent for the appellant for the purposes of effecting an inward diversion of the goods. 5, nor does HMRC allege that the appellant's alleged French cash and carry customers were the appellant's agents as regards the inward diversion of the goods to the UK. So it's recognised that somebody, either a supplier or a customer, is behind the inward diversion of these goods from France to the UK. And it is expressly stated that that person is not the appellant's agent. So the goods, the excise goods that were held in a tax bond, and that's common ground, they were at some point originating in a bonded warehouse in France. See paragraph 40 of the statement of case where I made that point. Modus operandi. These are excise goods held in bond in France. Somebody takes them out of bond in France and ships them to the UK. Does so using duplicate ARC numbers. That is the inward diversion. We say, well, are you saying that we did that? Answer, no. It's either your supplier or it's your alleged customer who has dispatched the goods in a fraudulent way to avoid the payment of duties that would otherwise be due and or VAT.
I mean, it's a slightly, it's a sort of curious bit of pleading in a way, of which the request is being made. It's not a conventional plea, because all it's saying is, in fact, the indications are, which is, not conventional pleading, obviously, where you say, we allege X. So I'm not quite sure what the status of this plea, this allegation is. It doesn't seem to be nailing its colours to that mast, but it's saying this looks as if maybe what happened. I don't quite understand this mode of pleading, really.
My lord, what's not being said is that we delivered the goods to the United Kingdom.
It's no.
And
it's not being said.
No.
No.
What is being said is that the people who delivered the goods to the United Kingdom were the people who were orchestrating fraud. We don't know specifically who they were, but they were either your supplier or your customers. Or
Yeah.
of the
No, I see that. They're saying that's what the indications were.
Well, they're saying that is what had happened.
It's
And
not alleged.
this is so we could understand. Are you saying we physically delivered these goods to a cash and carry in Romford? Answer no. That isn't the case that's being made. It's never been suggested that we instructed hauliers and told them to enter the goods onto the EMCS and ship these goods to Romford,
No.
and we then sold them.
But they do say you sold them.
Well, yes, they say we sold them, but that's, with respect, logically incompatible with the suggestion that we've already got rid of the goods to somebody else and they've taken care of those goods and brought them over here. There's no suggestion that the people who brought the goods to Romford then gave them back to us so we could sell them.
Well,
Well,
because we just don't know what happened, do we? I mean,
No.
so often we live in an imperfect world, and particularly, I mean, in cases of this nature, people go out of their way not to keep easily traceable paper chains of exactly what happened, and so it can be every movement can be audited. I mean, that's part of the problem. But one comes back to the Brady point that that one can run a case which is perfectly compatible with fraud on the part of your clients, even though it is not positively alleged against them.
My lord, what has to be seen is what HMRC is saying is the position. And the facts necessarily that follow are as follows. We held excise goods in France.
Okay. And this is a statement of the case for a hearing which is yet to take place, at which all the evidence is to be heard and explored. And ultimately, of course, the FTT make their decision on the basis of the evidence they hear at the trial. So, I mean, all this is important, but it's not necessarily by any means the last word in the story. And of course, the FTT also have the right, as long as they act fairly, to come up with a conclusion of their own, which may not be precisely one which was put to them by either side.
My lord, the FTT's reasons were, as your lordship's aware, based entirely on a rejection of the explanation of the money, the origin of the money. So it dealt with the origin of the money.
I mean, that's the slight difficulty that you obviously are only too well aware you're in. The person who does know exactly what happened is your client, or Mr. Judd behind your client. He told the FTT what he said happened, and he was disbelieved. So all the rest of this is speculation. But what we do know is that the HMRC assert that a ward supplied these goods in the UK. How they got there into the UK, no one quite knows, perhaps.
My lord, it's a little more complicated than that for the simple reason that there is an assertion here that the person who has removed the goods from France for delivery to the United Kingdom is not my client. And therefore we say it follows.
Well, I suppose, I mean, I'm to read this as an assertion that the diversion was done by the supplier or the customer. So I'll accept that for the moment. They're asked, will they clarify who the supplier is? And that was the supplier to you. It does not allege, because it doesn't have to, that the supplier was your agent.
Well, it goes further than that, my lord, if I may say so. 124, it says the supplier of the goods is the one that diverts the alcohol back to the UK.
Sorry, where is this? At
Page
124.
124.
Well, I'm sorry. I'm taking. I accept that leaving aside the indications are and what that means, that either the supplier or the purported customer diverted. Yes. But they then don't commit as to whether the supplier was your agent or not.
No. But what they do say is that the supplier was not acting as our agent for the inward diversion of the goods.
No, that's the point. They don't allege it.
Well,
but they don't assert that he wasn't your agent.
my lord, if I may say so, we are seeking to ascertain: are you saying they were acting?
I know you are, and they're not giving you what you want.
Well, they are in the sense that we're not saying it was you.
But they don't. Isn't that the whole problem for you? That
No.
they don't actually have to say whether it was you or not.
Nowhere is it suggested that we physically transferred these goods. On the contrary, what is said here in clear terms is somebody else has transferred the goods. We don't know who they are, but somebody else has done it. And that is enough on my case for me to say it's been accepted that we did not transfer the goods.
I see. So, right, okay.
Well, my lord, that's the position you end up with, properly construing these further and better particulars. It matters not in a sense what...
So you say that this is an acceptance by HMRC that award did not what?
Did not deliver the goods to the United Kingdom.
Deliver or cause
Dispatch
them.
or deliver.
Yeah.
Somebody else took charge of...
When you say took charge, I mean, what are we actually talking about? I mean, clearly you'd have a haulier who took the goods across through the tunnel or whatever.
Somebody else.
That's not you.
No.
But the point is, who was the haulier engaged by to do it?
That's part and parcel of the inward diversion fraud.
Yes.
And
So
we're not party to that. So
you say that this is HMRC accepting that that these were not your goods when they crossed the channel.
This is me. I'm going to make a legal submission on the basis purely of the facts. The facts as conceded by HMRC.
You say this is a concession or acceptance that award did not deliver the goods cross-border, nor were they, and you say it's an acceptance that they were not awards goods at that time.
I'm saying that they weren't awards goods at that time because award had lost the possession and control of those goods and no longer had control over those goods because otherwise it would have been either awards or awards agent who was responsible for the transfer or dispatch of the goods across the border. And that isn't, it's acknowledged.
Award had, lost possession and control. You say there's an acceptance that they had lost possession and control.
My lord, they don't deal with it in those terms. The legal submission that is the overlay on the underlying fact pattern is the legal submission that asserts that there is a transfer of handing over of the goods to somebody else. Why do I say that? Well, because the goods have been handed over to somebody else so that they can be physically delivered to the United Kingdom.
That's ambiguous, isn't it? I mean, handing over goods could just be literally be a physical delivery.
So I am seeking to tie this into the wording of the Principal VAT Directive, Article 14, and to the way that a supply of goods is defined under the VAT Act, which we didn't quite get to.
No, and helpfully, because it's much easier to have a look at those in the light of what you're saying. Okay.
So we'll learn from the experience that it's better to start with the facts and then
Well, it all depends, but when it's as complicated as VAT, I think it often is.
Well, my lord, the facts are these, if I can summarise it
Yes.
as succinctly as I may. So there were excise goods in France. It seems to be common ground that those excise goods ended up in the UK. We're not in a position to know that, but that's the basis for HMRC's case. And we haven't disclosed. So the goods are physically delivered at some point to the United Kingdom and sold. And that produces cash. But that physical delivery is recognised by HMRC not to be carried out by us.
Well,
So that cross-border dispatch is not
so
carried out.
HMRC recognises that the cross-border dispatch was not carried out. Now, would this be right? By or on behalf of award?
That is correct, because the relevant paragraphs we've been looking at, 2 to 5 at page 125, deal both with direct involvement and involvement as an agent.
And that's the point. This is dealt with. This is as I say, this is on paragraph. This is 124 over to 126. Right. Right. Thank you. So, if that were right, you're saying that in order for award to have sold the goods in the UK, it must have reacquired them once they were in the UK.
Well, there would need to be, once we no longer have them,
Yeah.
they no longer come back into our possession.
Well, they might do, but there would have to have been a subsequent transfer
Yes.
of the goods back to you once they were in the UK. In order, if it's right that you sold the goods in the UK, and if it's right that they were not dispatched by you or on your behalf because they had ceased to be your goods,
Yes.
then there would have to be an intermediate transaction in the UK by which you reacquired those goods.
So rather perversely, that would be a taxable acquisition of a cross-border delivery of the goods.
I mean, I'm just saying that that's what would have had to happen in order for there to be a sale by award in the UK.
Well, we would have had to be the purchasing party in the United Kingdom from the persons unknown who had by then taken possession and control of the goods and were supplying.
I mean, the obvious point was, what on earth would be the point of doing that?
Yes.
Right. I follow.
Plus also the logical consequence would be that the VAT assessment should be on the basis of an intra-community acquisition of goods which we had and disposed of, to put the matter neutrally, in France.
Right. Okay.
Now, my lord, I fully take on board the point that one can have transfers of goods on a duty suspended basis between a warehouse in the UK, sorry, a warehouse in France and a warehouse in the UK, for the purpose of then making a subsequent supply, so that they are always held in duty suspense, so that you're simply physically moving your own goods from one tax warehouse to another, and that can and does happen.
Oh, yeah.
Extensively in the wine trade in order to get French wine over here.
Yeah.
So that, of course, can happen. What marks this case out as not being that type of case is a recognition that there's been the intercession of a specific inward diversion fraud, which we are not alleged to be a party to.
Yes, I see.
So goods are in France, they're smuggled into the UK, that's their case. That's what they say happened. We say, well, are you saying that we were the supplier who had taken the goods into possession and made the delivery? Answer no. Are you saying that the person who did that was our agent? Answer no. And regardless of the Brady claim, as a litigant, my client was entitled to have the issues narrowed before the tribunal so that the correct factual basis was properly understood. And no matter how one might portray some of these pleadings, we say de facto they amounted to a concession that it wasn't us who had dispatched the goods cross-border.
And is this really the critical point?
Yes.
Yeah. Okay.
And the reason, my lord, it's the critical point, is that if it's not us, it's somebody else. If it is us, then we are intrinsically bound up in the fraud. And that goes back to my point I was making earlier, which is there's this inherent tension between HMRC's decision to say this is all part and parcel of the fraud, but it's not for us to prove. And what they could have done was simply say there's unexplained money, you tell us where it came from. At which point we're a classic Brady territory. Now, because HMRC have stepped out of the classic Brady territory, and rather than saying simply it's all up to you, they've put forward a case. And remember, my lord, they had initially pleaded this as a fraud case. And so when my client's advisors approached this, they're saying, well, you were alleging fraud. What's changed? You're now saying we don't have to prove fraud, but it's exactly the same consequences. That obviously makes my clients nervous, and they appreciate the Brady point, but at the same time they want to get to the bottom of what exactly are you saying, how exactly are you saying that these goods arrived in the UK? And precisely because there is this movement of goods across the border, that takes this out of a classic unexplained cash, you're a business, where do you say this comes from, the onus is on you. Because they have ventured to say not only that these goods have come from a certain destination, they've tracked back through the supply chains. They said these goods have come from France. It's part of an inward diversion fraud. That's a necessary part and parcel of their case. But that brings with it certain logical consequences for the VAT treatment. Unless, bizarrely, you're going to allege fraud, in which case it doesn't really matter what the transaction chains were because they would be treated as sham. So we end up in a position where we say these goods existed, they were in France, they were on French soil, they are moved to the UK, we didn't move them, the people who moved them weren't acting as our agent, and they arrive in the UK, and what you say is that by virtue of a subsequent sale in the UK by people you can't identify, the consideration comes back to you, therefore it's your sale. And we say, with the greatest respect, that simply ignores the cross-border nature of what necessarily must have happened. Now that, I think, takes me to a place where I can move off happily the FBPs. I mean, just for your lordship to note and your ladyship to note, there is then a series of what I would call jockeying for position between solicitors where between, from tabs 11 through to 13, my client's quite keen to understand that no fraud is in fact being alleged because of the change of position. That confirmation is given, for example, tab 12, page 130, we're not pleading a case of fraud against you. There's then some observations made, for example, at page 134 as to how it can be said we've supplied these goods in the UK if in fact they've been party to a fraud that we're not involved in. And that, in a nutshell, becomes the defining characteristic of this particular submission. Now, what then happens is in written closing submissions for the FTT, HMRC confirms certain points. So this is at Supplemental Bundle tab 4, page 135. I think I've given myself the wrong reference there. I think it must be 14.
Sorry, supplemental
14,
bundle
I think, yes.
40.
135. I've got it down.
5, right.
Yes, HMRC's reply submission. And then at page 143, which I hope is paragraph 22b.
Yes. 143, paragraph 21b, did you say?
21b, yes.
Yes.
Top of the page. What's being said is, moreover, all the evidence as to what happened after the in-bond change in account holder was that the goods...
Sorry, that's my fault again.
Sorry,
I just haven't got that reference. Oh, more halfway down.
halfway down, moreover. Yeah. Moreover, all the evidence as to what happened after the in-bond change in account holder was that the goods were very often ended up being transferred back to the UK via one of the wards.
There's several references to being transferred back to the UK. That's not in the sense of having originated in the UK, is it?
I think that is what is being suggested.
It originated.
These goods were on some sort of carousel loop.
Oh, I see. Was it English or French beer?
That I don't know.
Right.
I'm told there's no carousel allegations.
No,
so
okay. Anyway, there we go.
This isn't my document.
No, indeed. No, I'd noticed it a number of times. I just wondered why it was
flaws of all of
used.
its own, I promise.
Yeah.
So the back is redundant. The back shouldn't be
Yeah.
there.
It appears so.
Yes,
Okay.
okay,
I was
thank you.
speculating as to what was lying behind the pleading.
Okay, so more overall.
My understanding of inward diversion fraud is simply that it takes advantage of the arbitrage in duty.
Yes.
rates, and therefore we don't actually need an outward leg.
No.
And why take the risk of an outward leg when you can make your money anyway?
Very often ended up being transferred via one of the wards.
So insofar as we're dabbling with the evidence here, what's being said is not that you were responsible for delivering the goods back to the UK, but your client, your customer was, Scorpion. And you'll recall that the statement of case had pleaded an express example of goods being seized on arrival for Scorpion. There was then a restoration claim, but which was rejected, no appeal, and it was said that the goods in question that Scorpion had been bringing back in had originated with us. That was the allegation. We then see paragraph 76 at page 170.
Sorry, I'm not really quite sure what I meant to get out of 21b, the bit you've referred us to.
Well, to the extent that evidence is referred to, all of the evidence is consistent with the assertion HMRC have made, which is you are not the one who is bringing these goods in. So their case is...
Well, I'm not sure I can quite get that out of that, but there we are. I mean, it's quite difficult to, 2 sentences in reply submissions after a full hearing to understand what's being said. But anyway, sorry, your next reference
Page
was
170, paragraph 76. Is confirmation at the last 4 lines of paragraph 46. It said the only other way for brands targeted to a home market to get back to the UK was via IDF, which is inward diversion fraud, and there is clear evidence for that in this appeal in the form of Mr. Llewellyn's evidence. The tribunal is invited to accept that this is the only plausible way in which the goods were returned to the UK. Again, it's the concept of return rather than delivery, which my learned friend will no doubt explain, but suffice to say at this stage, what's being said is that the physical delivery of the goods cross-border was part and parcel of a fraud being operated by people, and that fraud was being operated by, not by us, but by a supplier and or one or more of the so-called customers. So that is the way that the case is being put, and that necessarily implies, we say, that there has been a physical delivery of these goods by someone other than us across an intra-community border. Now, to some extent,
just hold on. It necessarily implies there has been a physical delivery into the UK by someone other than the ward.
yes. I mean, just standing back and sort of looking at it from a very high level, the allegation that's being made is these goods have been sold in the UK by you or on your behalf. What does that connote? Well, that might connote a direct delivery. That's ruled out because they've accepted that these goods were delivered through the auspices of an inward diversion fraud to dodge duty, and that was done by people other than us. And the people who are doing that weren't acting as our agents.
Well, they're not alleging they were acting as your agents, is that right?
Well, my lord, there's no suggestion that the delivery took place on our instructions. We have delivered the goods, removed the goods, however one wishes to put it. The goods have ended up in somebody else's hands other than our own. We no longer possess them. And what has then happened is somebody has instructed an haulier to load those goods and bring them across the Channel Tunnel or by ferry. And the example that is given in the statement of case refers to a seizure of goods at Coquel. So before they've entered the Channel Tunnel, the lorries pulled up, HMRC, UK Border Force officers investigate what's in the load. They don't like the ARC, so they seize the goods. And that is evidence, according to HMRC, of the modus operandi of the inward diversion fraud. Now, there's never been a suggestion that it was us that was doing that and pulling the strings and orchestrating that movement. On the contrary, it's been recognised by HMRC that that is done by other people. And so possession of the goods has necessarily gone to other people to enable them to do that. It necessarily follows. And that's the very point Lady Justice Rose made in giving permission, that by virtue of somebody else having been involved in a fraud with your goods, somebody else has taken possession of them and is responsible for the delivery of those goods to the United Kingdom. So it's the intercession of other people unknown to us in the physical movement of the goods that we say makes all the difference for a VAT analysis. Because it means you can't say there was a direct delivery by us to the UK. Somebody else has done that. And so you end up with a series of imponderables as to what happens to the goods once they've arrived in the UK. But the one point I can make good is that once you have an arrival of goods in the UK, which necessarily follows from the Commissioner's case that there have been a sale of goods in the UK, they must therefore be here. The person who has received those goods is the person who has a tax liability under the VAT Act, giving effect to the principal VAT rate. And that's the key part of our case. So now all of this was understood to a certain extent by the First Tier Tribunal. If we turn perhaps then to the First Tier Tribunal's decision. This is in Core Bundle, tab 12. Page 224. sorry, tab 13, page 224. That's where it starts.
Sorry, tab, sorry.
Tab 13,
Tab 13, yes.
page
Thank you.
225.
Thank you.
And we see paragraph 3. HMRC do not accept that this is the case, that's our version of events, and contend that having traced the relevant supply chains, so this isn't simply we don't know where these goods have come from. They've actually done some work to work out where the goods have come from. The goods sold by Award Drinks had entered the UK as a result of an inward diversion fraud, and supplies were made in the UK and therefore taxed.
I'm so sorry, which paragraph are we at?
That was paragraph 3, my lord.
Paragraph 3, thank you.
Page 225.
Yep.
So it isn't simply there's an unexplained amount of money, which must therefore be cross-referable to taxable supplies made by you in the UK because you're a UK registered taxpayer. We've got the intercession of specific facts that HMRC positively puts forward. These goods were in France, they're no longer in France because of an inward diversion fraud. Therefore, a necessary feature of HMRC's case, that these goods had been transported from France, where lower duty was payable, and that they had arrived through a fraud system that involved using mirror loads under the Administrative Reference Code document, the ARC, in order to dodge the otherwise strict monitoring function of the Excise Movement and Control System, the EMCS, which is the computerised system for making sure that where loads enter the system in France, they're discharged on the system in the UK when they arrive. We then have at paragraph 6 a description of the inward diversion fraud. My lords, my lady, why bother with a detailed description of how the fraud works if this was a direct delivery case? What changes then is that in 7, rather than seeing how the commissioners had initially approached this case to begin with, namely the classic Kittel allegation that you were involved in transactions that led to fraud and you knew or should have known of that, that isn't being alleged. And instead what's being said is we've raised assessments on the basis of a taxable supply of goods in the UK. That taxable supply of goods in the UK has led to consideration being paid. You've received the consideration, therefore you must have made the supplies. With the greatest respect, that simply doesn't follow, because VAT transactions are not simply about who receives the money, it's who supplies the goods.
It doesn't necessarily have to follow, does it? It's just sufficient for HMRC to make the assessment.
They could make the assessment and say there's an unexplained pile of money in your bank account. Yeah. We say it must relate to a supply of goods.
In the UK.
You haven't proved that
in the UK.
No.
You haven't proved that it's not in the UK, therefore,
Well,
bad luck.
Indeed. There was no challenge to the assessment
But
as
they've
such.
said that, haven't they?
My lady, no, because what they've said is these goods were based in France. The goods then were delivered to the UK, and through the interlocutory skirmishes that we've seen, we were very keen to pin down exactly what was being said about our involvement in that delivery process.
But why does it matter? If the core of HMRC's case is that you were making sales in the UK and that the cash that was deposited in all those not penny numbers, but in various amounts in Blackwood, in Wales, Laing, Lancashire, and all the rest of it, represented the proceeds of those sales. Why does it matter what happened before that?
Well, my lady, because it's our goods that are being said to have been in France and held in France.
Yeah.
And what has been stripped away from HMRC's analysis is how, as a matter of VAT law, those goods represent a supply for UK VAT purposes in the UK. And that involves a consideration not simply of monies received, but of the physical underlying supplies of the goods in question. Because VAT law works not on the basis of, well, you've received cash.
No, but you come back, I suppose, to where we started. I put to you, it was your case that the money in the bank account represented the proceeds of sale made by you.
Yes.
Yeah.
That was not an issue.
Correct.
So if it wasn't in France, because that was rejected, where was it?
Well, my lord, because of the place of supply rules, it's crucially important to work out whether goods have moved across a border.
Well, okay, they did.
and
But I think the only way you can put this case is, isn't it, that, and this is, I think, perhaps what you are saying, that HMRC made a concession,
Yeah.
the effect of which was probably not really spotted at the time, the FTT, but which was sufficient at that time and is now sufficient totally to undermine the FTT decision and to lead to only one result, namely that the appeal should have succeeded before the FTT. And this wasn't argued before the FTT
Well,
in the way you're putting it to us. At least it's not reflected in the least in the decision.
it's not reflected in the decision.
Well,
I fully accept that.
I will take it wasn't put to the FTT because it would have been considered. I mean, you can prove us wrong, I suppose, by reference to submissions made. But I mean, one would have expected this case to be put properly and to have been answered properly. If it was put properly but not answered properly, that would have been ground one of your appeal to the Upper Tribunal. But they don't deal with this either, I don't think. So you're now in the position having to say, well, actually, if we go back, we will see that HMRC made a concession which is fatal to their entire case. And that's the only way you can do it, isn't it?
My Lord, can I trail what my submission will be, which is that this submission was made at first instance, but simply wasn't dealt with.
And was it raised as a ground of appeal to the Upper Tribunal?
My Lord, it was raised as a ground of appeal to the Upper Tribunal in the context of an overarching attack on the way that the First Tier Tribunal had dealt with things. So there were two grounds of appeal before the Upper Tribunal. Firstly, that the First Tier Tribunal had failed to understand the distinction that was necessarily involved between looking at the money and looking at the underlying transactions, and hadn't properly taken into account the transactional evidence. And secondly, that there was a failure to give proper reasons. And I can take you now to.
But that's a different ground of attack from saying a major part of our case was X, and you haven't dealt with it.
Well, this argument was fully articulated before the Upper Tribunal.
The one you're now
The submission
putting to
was
us.
made before the First Tier Tribunal, but the First Tier Tribunal didn't deal with it.
Right.
The
Okay.
fact that the First Tier
I see.
Tribunal hadn't dealt with it was clearly put before the Upper Tribunal.
Yes. Well, I'm sorry I interrupted, my lady, because I just felt that, you know, unless you say there was an absolute clear-cut concession by HMRC, then I just don't see how this could have any traction at all, because you'd then be in an area which was not explored as a matter of evidence. You didn't put forward the evidence that was required to explore it. That would be the
My Lord, there was a positive averment by the commissioners that these goods were in France, and then they were removed to the United Kingdom in the course of an inward diversion fraud.
Yes, well, that's not enough to get you home. What you have to go on to say is, and HMRC accepted, that we were not involved in it.
Well, they accepted that we
They
had not
conceded.
physically transferred the goods.
Well, that won't be enough. I mean, you've got to show that it wasn't done at your direction. I mean, the physical transfer doesn't matter. It's a question under who's got possession and control of the goods.
My Lord, physical
Legal possession and control.
that goes back to the legislative framework that I was deploying earlier.
But you're not concerned with in whose lorry the stuff is. I mean, it's a question as to who owns the
My Lord, it's a question of the goods having been handed over to somebody else, so we aren't in control of the goods.
What do you mean by that?
Well, what I mean by that is that once we no longer have the goods, we've.
But when you say you no longer have them,
Yes.
I mean, clearly you no longer have control of the goods in the sense that once they're on somebody else's lorry, you can't control whether he crashes the lorry or something. But, I mean, if they are still in your legal ownership,
But they weren't, my Lord.
well, that's what you're saying.
Well, how do we know that? I mean, that's the bit I don't understand.
Well, it's been
One of
said
the
that
bits.
we have sold these goods, and somebody else has got hold of our goods,
Yeah.
and somebody else has smuggled those goods across the border.
Are you saying that HMRC is saying that you sold the goods in France?
But they have to, otherwise we haven't got any sale for
I
consideration.
don't. Sorry, you go.
No, you go.
Well, they've
I
simply,
just don't understand why any of that has to be the case.
well, my Lord, because the goods that are in issue are goods that started in France
Yes, I know.
and were held by us. And it said we've sold those goods.
In England.
In England.
Well, that is the crucial question.
Well, that's what they say.
The suggestion that we have sold those goods in England is inconsistent with us having surrendered possession of those goods to smugglers.
Well, surrendered, well, that's rather, your choice of words is interesting there. I mean, supposing you retained ownership of the goods.
Yeah.
Well, my lord, that would be irrelevant under the legal test for what constitutes a supply of goods.
It all depends what you mean. How are you defining possession in these circumstances? Are you
Possession
just
would be
physical possession?
and the right to dispose of the property as owner.
Okay, all right. Well, that, I think, is ownership, really. But
Well, one could hand over the goods with a view to saying, right, that's it. We have, as far as we're concerned, we no longer have any claim to those goods.
yeah, well, that means you've sold them, or if you've received anything for them, or
Yes.
given them away.
It means we no longer have possession of them, and there's no suggestion that the people who received those goods did so as some sort of bailee.
Yeah.
So they hold those goods in their own capacity, and they dispose of them as they see fit, and they choose to smuggle
Where's
them.
the evidence about this?
Well, my lord, the evidence is HMRC's recognition, stroke acknowledgement, stroke concession.
That's the point, isn't it? There is no evidence about this. Your clients didn't produce any evidence to support this theory because, of course, it's wholly inconsistent with the case they were putting. That's why I think I can only see your case having any traction on the basis of a concession by HMRC.
Well, it's a positive assertion of what their case is in paragraph
Well, that's
40.
the point, isn't
Yes.
it? That is the point.
I mean, they are the ones who have looked at the supply chains and gone through them.
Yeah. You say that it's a positive assertion, if you like, a concession. I think that word is used. It's actually used by the Upper Tribunal. A concession or an acceptance that you had disposed of the goods, of your interest in the goods. Is that right? You disposed of your interest in the goods in France. And of course, in English terms, that wouldn't make much sense. You were you had the property and the goods, but I don't quite know what the French law on that is. But nonetheless, you had been the owner of the goods and you ceased to be the owner of the goods.
It's sufficient for a
In
supply
France.
of goods for the goods to be physically handed over to somebody else for use at their will.
Yeah. Okay. Well, I follow that. Without any obligation to account to you for anything.
So one of the many hairs that's been set running in the legal arguments below concerns retention of title clause.
Well, I hope we're not going to
No.
look at those.
And the reason why they're not relevant is because you can still have a supply of goods even if you retain, in theory, title to the goods
Okay.
down the line.
All right.
And it's been well shown.
But anyway, you're not saying that's this case.
No.
No. You disposed of the goods. You say that's the concession made.
But somebody else has physically carried them across a border.
Oh well, that's easy. Yes, that doesn't get you anywhere then.
Well, if they're not acting as our agent,
Ah, well, that's the point.
then on what basis do they hold those goods?
Yeah.
It
And,
can
and
only
how
be-
could you have sold them in England? That's what you're saying. Because you'd cease to have them.
Well, as a matter of VAT analysis, it doesn't matter because there is an interceding VAT transaction that gives rise to a chargeable event, regardless of how you skin that particular cat, because it's either a supply in France by the person who holds the goods, or it's a chargeable acquisition
By
in the UK
by X.
by
in the-
whoever has received the goods.
by
And that the assessment has not been raised on the basis that you, the taxpayer, have received an intra-community acquisition of goods which you failed to account for. That's not.
No, they're saying it was raised on the basis that you sold these
sold
goods. You sold these goods in the UK,
Yeah.
and you received the proceeds of sale in the UK,
Yes,
and that's it.
yes, which falls down on the basis that we can't have effected a sale of goods that we've got rid of the other side of the channel that have been physically delivered by somebody else who wasn't our agent.
Supposing, I mean, go back to the point. I agree. It may be slightly unlikely, but supposing you had reacquired them in the UK
Well,
and then sold them, would you not then be accountable for VAT on that sale?
we would have the ability to recover the acquisition VAT that would be chargeable on the transaction.
But you still have to put in a return, wouldn't you?
Yes.
And yes, all right. Yes, right.
That
So it makes it very, very unlikely that you would have actually sold and then reacquired once they got to the UK. That's the point.
well, it's, with respect to vanishingly unlikely is
Yes,
to be
exactly.
credible.
I follow that. So the question becomes, did you dispose of them while they were still in France?
Yes.
Yes. And you say the HMRC conceded that you had.
They had necessarily conceded we had because they recognised somebody else had taken charge of delivering the goods. And
Okay.
they weren't our agent. So
All right.
the FTT's reasoning on this, will probably come back after. I mean, part of the problem, for me at least, is you're asking how a particular matter was put to the FTT, but the transcripts aren't in evidence.
Well, I mean, the
I
VA.
can-
I mean, when you say how was this dealt with by the FTT, I mean, the answer is that. Well, let's see. Yes,
Yes,
I'm about to say it wasn't dealt with by the FTT.
It's sufficient
but
for my
it said
purposes just to
something.
say they didn't approach the matter in this way at all.
No, quite.
So the reasoning starts at page 251, behind tab 13. And they make the Brady point at paragraph 77.
Yeah.
78, they say the assessments were raised on the basis of deposits. Best judgment as such, the rationality of the assessments wasn't challenged, but it was said that they didn't reflect taxable supplies in the UK. The positive assertion of goods being sold in France is raised. The tribunal then at 80 to 82 essentially set out their entire reasoning for dismissing the appeal. And it said that there was no positive evidence that the...
Well, in '79 they summarise your case,
yes,
which is what they then go on to
deal with.
address and reject.
Yes. And they rejected on the basis actually not in relation to the underlying transactions, but in relation to our explanation of where the money was coming from. So whilst the entire focus is on the implausibility of couriers carrying money from France to be banked at various banking locations across the UK.
Well, it wasn't just that. There was a mass of other evidence which made your story totally implausible, such as the fact that the supposed buyer's premises were derelict and all sorts of stuff. I mean, it was partly, of course, the couriers and all that. There was a lack of any customs declarations. There was a mass of material, wasn't there?
None of that, my lord, is dealt with here in the
It
reason.
was dealt with throughout the decision.
There are references earlier, but
It's
when,
very clear. Yeah.
this is discussion and conclusion. And so whilst the evidence has been set out, the concluding...
Well, I mean, paragraph 80 deals with a number of points, doesn't it? Raise. Anyway,
Yes.
there was a. I mean, the case was rejected.
Ultimately, the reason I haven't focused on the FTT decision is because it was set aside by the Upper Tribunal, and because Lord Carnworth...
Well, on the basis that they hadn't addressed the documents, which in this court we proceed on the basis were bogus.
that is
So it's a sort of, yeah.
Yeah. So we are where we are.
I mean, yes.
Lord Carnworth in
I mean,
Pendragon said the focus has to be on the Upper Tribunal's decision, so I confess that I've concentrated on the submissions that were specifically made to the Upper Tribunal, but over the short adjournment I will find the specific
Yeah, I mean,
submissions.
at paragraph 82, there is they reject the factual case. It doesn't hold water. And then they say, having come to such a conclusion, it's not necessary to address the legal submissions made on behalf of Award Drinks, as these were advanced on the basis of facts which we have found not to have been established, i.e., that Award Drinks sold the goods in France. So there was no factual basis for any sale by you of goods in France.
My lord, that goes back to my basic point, which is the fact that a sale is not found to have been made in France doesn't mean that there is necessarily a supply in the UK, because of the intercession of persons who were neither our agents.
Okay, not a sale. You say there must have been a disposal in France.
Yes.
Gave the goods away.
The goods are no longer in our possession by the time that they are smuggled over.
But you use the word possession again, which I find tricky.
That's because I am coming at this from a definition of what constitutes a supply of goods.
Yes.
Which is in Article 14 of the Principal VAT Directive and Schedule 4.
All right, but you're not meaning. You're meaning that. I mean, basically, they were not Award Drinks goods.
Yes.
Okay. It's okay. Fine. Yes. Right.
I mean, it may be at 2 o'clock. I need briefly to turn up the legislative framework in both the EU and the UK to show exactly what a supply of goods consists of. So it is the handing over of the goods for the purposes of
Yes.
them
Yes.
no longer being yours. And there's a case, Oliver, in which the contract of sale was void because a ringer of cars, second-hand cars, had been unlawfully putting together different bits of chassis in order to produce a bogus document and a bogus vehicle.
Right.
And held, even though the contract of sale was void, there was still a supply of the underlying vehicle. Case of Oliver. I'll come back to if I need to. But suffice to say that the supply of goods is a wide definition, wide import.
But you advanced no evidence that was accepted before the First Tier Tribunal that you had ceased to have possession in the VAT sense of the goods in France.
My Lord, the case we advanced was that by virtue of the Commissioner's pleading, it was necessarily implicit that somebody else other than us had brought the goods across, and therefore there was a vatable event.
So so there was a vatable event,
which wasn't attributable to us.
but that you gave no exactly. I mean, you based that entirely on what you say was HMRC's concession, not on any evidence.
Well, we had no evidence of exactly what people had been doing with our goods once we no longer had possession.
But you gave no evidence of ceasing to have possession of them.
Well, we tried to give evidence.
Yeah, no, you gave no evidence which was accepted, is what I said. So, yeah. Yes, right, okay. So where do we...
Is that a convenient
Well, it
moment
probably
before
is,
I
actually, yes.
Move on to the next point, which
Yes.
is to look at the Upper Tribunal's decision, perhaps a snippet or two of case law. I probably do need to take you to how it was presented, just to clear off that particular point. So if I do that, perhaps at...
Sure, 2 o'clock, very good. 2 o'clock.
in terms of timing, my learned friends benefit as much as anyone else. I would hope to be sat down metaphorically by, well, literally as well, by 3 o'clock or so.
Okay, fine, thank you. 2 o'clock.
Excuse me, are you locking up over lunch?